Is an employee handbook policy a contract? Imagine walking into your workplace and picking up a handbook that explains how things work around there. Have you ever wondered if that handbook is legally binding? Well, let's find out. Most employee handbooks are not considered contracts. They are mainly guides that tell you about company policies, rules, and what the employer expects from you. Unlike a formal employment contract, which is a signed document creating legal promises, a handbook usually does not guarantee your job or specific benefits. From a legal point of view, the main difference is that employment contracts involve mutual promises that both sides must follow. Handbooks, on the other hand, often include a disclaimer stating they are not contracts. This disclaimer is important because it helps prevent courts from treating the handbook as a binding agreement. However, there are times when parts of an employee handbook can be seen as contractual. For example, if the handbook clearly states specific pay rates, benefits, or disciplinary procedures without saying it is not a contract, courts might decide those parts are binding. This means you could relying on those promises as part of your employment rights. To avoid confusion, employers usually include language in the handbook saying it is not a contract, that employment is at will, and that policies can change at any time. This helps protect the employer from legal obligations they do not intend to create. For practical purposes, employers should carefully write their handbooks with clear disclaimers. Employees should understand that policies are guidelines, not guarantees. If an employer wants to make certain promises legally binding, those should be written in a separate employment contract. Regularly reviewing and updating the handbook is also important. Laws change, and keeping the handbook current helps ensure it remains a non-contractual document. In summary, most employee handbooks are not considered contracts under labor and employment law. They are helpful tools for understanding workplace rules, but do not create legal obligations unless specific language or circumstances make parts of them binding. Clear disclaimers and flexibility in policies help employers manage legal risks and clarify employee rights.